Hello, everyone. Welcome to Court with Krissy. After serving time for cyber stalking and now up for a possible probation violation, I'm not so sure this girl's flip phone can stop her from facing future felony charges. Let me know what you think in the comments. I hope you like it. Court with Krissy is now in session.
Morning. Sir Pascovich. Good afternoon, Pascovich. Carrying on with people. Mr. Smith.
Hi, Sean Patterson, gonna come back. Sorry,
All right, we've got a number of things going on today, so I just want to make sure.
whatever order you think is.
Well, we can start with your motion.
So this is my motion to get some jail credit or an alternative to other things. Read the motion. One of those other things would be to vacate the tether requirement that we have on there. I'll get to that later. So I did do some research on this because it's a very interesting issue. I did it as of late, so it's not included in any brief. If the court feels any time that you want me to pause and come back at a later date with my findings, but I think it's very simplistic. Normally, the court has discretion in sentencing under the MCL 769.1. That's the indeterminate sentencing law. This is spelled out in the case of People v. Atkins 433-ish 732 and footnote 10 of that case. They say, in that case, our opinion today, however, must not be seen in any way prohibiting a sentencing judge from granting sentence credit for time served in an unrelated offense should it be decided that such credit is warranted. It basically gives you the option to say, look, I feel like something should be done. However, then, twist of fate, years later, an unpublished opinion that I just located called People versus Jamil, two E's, McGee, out of Berrien County, decided unpublished on the 23rd of March 2023. They also go through that same kind of analysis. This guy was arguing that instead of 48 days, he should have got 414 days because he was waiting during COVID for his trial and all that. And they said, no, you're not getting that because, and they relied on the statute that the prosecutor said in his brief. But they also cited Atkins. They talked about Atkins. And they said, in the end, they said, which was interesting, they said, after they said that he shouldn't get the credit, they said, further, the trial court specifically exercises discretion, which is what that first case talked about years earlier, by reducing the defendant's minimum sentence to accommodate his not receiving much jail credit. In other words, he didn't get the 414, he got the 48, but the Court of Appeals in this case recently said, no, it's kind of an offset. The judge did use his discretion by not giving him, because he didn't give much jail credit. And they said that, let me quote this exactly. Further, the trial court specifically exercised in its discretion by reducing the defendant's minimum sentence to accommodate his not receiving much jail credit, comma, in the manner foreseen by our Supreme Court and clarified in Act, is the case I just talked about, at 433 Mish at 751 Note 10, period. The trial court ultimately sentenced defendant to 22 fewer months than it could have, while remaining within the sentencing guideline range. So even as of recently, the courts are saying that you have some discretion. So I'm asking you to use your discretion. And it's not a lot. If she doesn't violate anything in the future, it doesn't really have much effect on it. But if you were to give her the credit, I think it would be within the bounds of the law and it would be reasonable. And it's, of course, your discretion. So I guess that's where I'm at. And if the court doesn't see it that way, there's other options under the McGee case, which was just recently cited. You can exercise your discretion in another way by reducing the defendant's sentence to accommodate the fact that she did extra time, which is what I'm getting at when I say, maybe we close this case, let Bloomfield take over and we monitor from a distance. Or maybe we remove the tether requirement, which Bloomfield doesn't have. More serious case, they didn't see the need for a tether requirement. All the same people showed up for the sentencing in on that case. I mean, the whole galley that was here that day was there in Bloomfield. I wasn't the lawyer, but I know that to be a fact. They had their say and they made their point. She got additional jail time because their presence and the acts that were alleged, which were the same acts that violated your bond, the use of social media. So I'm just asking you to use your discretion. You clearly don't have to. We're starting off on hopefully a fresh start in somebody's life, but well, it's neither here nor there whether or not, according to the law, it doesn't have to be the exact thing, but actually she was sentenced on almost the exact same thing.
It's up to me.
It's all up to you.
It's all up to me.
And you're gonna hear that there's, that she's gonna be with you for a while, and that maybe it's the best to keep her here. I don't know that that's actually the way I would look at it. I know you like to hold your brush, and I talked about it. You don't like to have other people looking over things that you set in motion, and you like to make sure that people learn something. Which all these people talk. What's interesting to me is that 99% of the time when I'm here and I get to see these things there, I'm actually proud of being a lawyer. And I'm proud of what I see. I'm proud of what the system does for people that seem like they are caught in the washing machine that keeps going round and round and round, like the last guy. I mean, that's really why we're here. So,
Okay.
and I hope that and I'll give you a heads up right now. My client, they listened to some recordings while she was in jail, and she was upset. The first third of she was upset. And they listened to all the calls privately between a husband and wife. And I can only imagine if someone were to spend 7 weeks listening to my wife and I bicker about the stupid stuff. We bicker about her things she says to me sometimes. I love her to death, but she's not a perfect person.
And Mr. Smith, I've known you for a long time and we get along very well, but I imagine that you'd acknowledge that you're not a perfect person.
No, absolutely not. And that's, I'm way more enlightened than I was 30 years ago. Our anniversary is in July, by the way, so.
Congratulations on that, Mr. Smith. And this is I will tell you right now, Mr. Penskovic, I won't need to hear from you. I think I mentioned it at the time of sentencing. I am not inclined to grant your request, and I'm going to use my discretion to not grant her the additional time. And it's frustrating only because there is good lawyering done and there's good advocacy that's being done on this Hodgson's behalf. The challenge is that she continues to make choices and continues to stay in a mindset that makes it very difficult for a good advocate to get stuff done. And that's frustrating on my end because these charges started off much more serious than what she actually pled to. And it had nothing to do with her behavior, and it had everything to do with excellent lawyering. The work that you did in really pressing different issues and identifying different challenges in the people's case. It was not an exoneration. It was, a pointing out, are these the right charges? Are there different charges that are more appropriate charges? These were all efforts done by you. With the whole goal, I guess, from my perspective, when I put Ms. Hodgson on probation was, this work was done. Now it's time to earn it. Now it's time to come to the realization that all of this must come to an end. Now, some new allegations have come forth. That really hasn't weighed into my decision because, again, some of these things have come to the court's attention, and I'm sure to your attention, sort of at a later hour, and I would want to give you a chance to, prepare for and be prepared to defend these things. But you were asking ultimately for me to give her credit. I'm not, or asking for me to give her consideration to take the tether off. I'm not in a position to do that yet, especially with some new allegations. I want to see how that all plays out. But I want to make sure that this record is clear. Mr. Smith has achieved many successes already in this case and has achieved many successes in this court otherwise. He does a lot better when his clients put him in a position to have a chance to win. So the motion that is heard today is denied. All right, Mr. Veskulovich, it's my understanding that there's new allegations. This court has become, again, I don't have all the details yet. And so I may not necessarily be inclined to proceed today without giving the defense the opportunity. I'm going to keep certain safeguards in place, of course, with the tether and all that. But Mr. Veskulovich, if you could bring the court up to speed with what you believe are new violations.
Your Honor, I think that actually be most appropriate for,
all right, Mr.
probation, because they had direct contact regarding the matter, I wrote up the stuff.
Okay, go ahead.
Specific to
That's
the
fine.
issue that's written down in the report.
The only challenge is we're in a heat zone here, okay? Probation is going to bring to my attention anything that could constitute a violation. That doesn't mean that prosecutors can't also bring motions to violate. I mean, that certainly isn't the province of the prosecutor, and having done that job once, I do remember having to do that as well, because some probation departments don't react the way probation or prosecutors like, and so they can bring their own motions. But we'll start with your allegations first from the probation department.
Can I just,
Go ahead.
we did speak about this outside. These are not actual violations. They just want the court to be aware that these are things that potentially could have. There's no violation. That's what I understand.
Judge, I did not set a violation for today. I wanted to make you aware of it, only because I don't have documented verification of some of these allegations.
Okay, so right now we're still in a review status.
Technically, yes.
Okay, I would prefer things to be handled this way, so that if there is information that you have, that Mr. Smith has a chance to start preparing for these things in advance, because it doesn't mean that there won't be a violation set, because it sounds like there could potentially be if sort of the dots are connected. Is that what I'm getting at?
Yes.
Okay, so if you're wondering today how I would proceed, until I have an actual allegation of a violation, we're going to conduct this as a review otherwise. We're going to see how she's doing in all the other aspects of her probation.
Very well.
Okay?
Thank you.
So, as far as she's on the tether now, right?
She is, yes.
Okay, and any violations of the tether that you're aware of?
Judge, I do have an update. I did receive information from home confinement this morning that the defendant did drive past or through one of the exclusion zones last night around 9:04 p.m. For the record, she does not know all of the exclusion zone actual addresses, because I did not disclose that to her, because I wanted to keep it private. It's not public information, as they're relating to the victim.
Right.
There is a 500-foot exclusion zone, and my understanding from the tether company is that anytime she enters this zone, any of these zones, the tether itself would, all three lights on the tether will beep, or will flash, and then the device itself will vibrate until she is out of that exclusion zone.
Okay, so let's follow up with that. My main question would be, was the immediate reaction of the defendant to leave the zone? All right, so we'll have to find that out. Do you know that already?
I did not talk to her about that, but home confinement did let me know that she was only in that zone for approximately 1.5 minutes.
Okay, so that's what, so, and I actually think that's the smarter way for the victims to proceed on this. Even if it means that occasionally we'll have these moments where she's, you know, it goes off and then she has to leave right away. Because for their sake and for their safety, you know, some of the ways that it's done is the victim provides specific locations, and then those locations are provided to the defendant, and the defendant is told to stay away. But given the fact that we can't guarantee how long Ms. Hodgson's going to stay on it, if she's given those addresses, then when she's off the tether, then she could, in theory, go near those locations without being detected. And so I think it's actually a very smart move by the victims. And then what it means for us is we have to work a little bit harder. It means that we have to then take a look at any time that she goes into a hot zone, does she go there and linger? Because that says to me then she knows that somebody's there. But if she goes in and she goes out immediately, then the court would do that differently. Does that make sense, Mr. Smith?
Yeah, the only problem we're gonna have is that without the exact location, like, let's say they, hypothetically, let's say you gave me a tether, and you said I couldn't go near the prosecutor, but the prosecutor's office was in downtown Birmingham. I live in downtown Birmingham, and I go get coffee at my coffee shop, and that's on the edge of the ring of I'm not going near the prosecutor or his office, but the ring is encompassing the whole city, basically, or that whole area where my office is and where, so then what do I do?
Well, the circle's not that big, it's 500 feet.
Yeah.
It's not that big.
So just to explain in more detail, so she doesn't know where she's not supposed to go and not supposed to go, but she goes to a coffee shop with her husband, and they go get lunch at these places in downtown Grosse Pointe, which is smaller than Birmingham. And last night they were out at the place where she always goes, and all of a sudden her ring leaves.
And now she knows that that place is a place that she can't go.
So she can't go back to the coffee shop.
Correct.
Even though that.
It's within 500 feet of a location, that's it, that's.
But what if we want to contest and say that location shouldn't be a location because X, Y, and Z? The people that were concerned about all of it in Oakland County, why do they have exclusions in Grosse Pointe? Doesn't make any sense.
Well, because we can't guarantee the client, and again, people work at different locations, people frequent different locations. And so Ms. Hodgson's conduct is such that there have to be additional safeguards in place. And if there is an inconvenience not being able to go to a coffee shop, well, I guess I would just cite the fact that there are hundreds of coffee shops that she could go to as to not put the victims in fear of her close contact. And if it's a coffee shop within 500 feet of where the victims live or work, then that might be a place that they go to. And they have the right to be able to walk into that coffee shop or walk into that restaurant or walk into that store, knowing they're not gonna run into Ms. Hodgson because it's within 500 feet of a particular location that they've set. So again, I guess I'm less concerned because Ms. Hodgson has made choices that have put herself in a life of inconvenience. All right.
So to regard the tether, Ariel got out of jail on June 22nd. She had the tether on by about 3 o'clock that afternoon.
Okay, good.
So she had it on within 24 hours. We talked, she and I met on Monday. You know, she's brand new to this. I hadn't explained any of her terms to her until this past Monday. So she has not yet obtained the psychological evaluation. She plans to speak with her therapist about it. She assured me she's continued meeting with her therapist, and she will ensure that the therapist will send me verification and that the treatment does address the stalking, threatening, and harassing behavioral component. I have not received a documentation of that yet, but I believe that I will. She's looking into where to complete the 100 hours community service. She states to me that she has not had any direct or indirect contact with any of the victims. Their addresses or their places of employment. She states that she has not assaulted, harassed, intimidated, stalked, or threatened any of those 12 listed parties or any other person, place, or business. So I can kind of go into that, Judge. Regarding the potential violation, reach out to me over this past weekend indicating that, her friend Elvin, I guess, had received some sort of text communications from some burner phone numbers and from Ariel's husband directly, indicating some prior text messages that Ariel and they were friends back in March, April of 2024, had communicated about regarding Alvin, the boyfriend of Carol. And I was informed that it had been at Ariel's direction to her husband Dan to send this information to Alvin, the boyfriend. So I know that the prosecutor had let me know about that piece of it. I don't have the actual messages that were sent. So that was my basis for not setting the actual violation.
Well, because we have to see if there's an actual connection that occurs. Now, Mr. Pascovich, do you have any updates recognizing that whatever you have, we have to get to Mr. Smith, so he has time to review it and all of those types of things, but can you sort of verify what Ms. Lincoln said?
So, yes, so I'll start actually before that. Got a call from a private investigator named Tim Lennon a couple weeks prior, which was a private investigator that was hired by Ms. Hodgson, the defendant. He did work on the case. He had went to a witness's house, tried talking to him, interviewing him about the case. Everyone's very familiar with the investigator. So he calls once Ariel gets sentenced to jail and says, you know, or he sends a message, Ariel, ... not smart. He ends up calling her to talk, and he says that one of his clients is a cellmate of the defendant and told him that she basically caused Ariel to go to jail. He was trying to get more information on how that went down. She found it to be very strange and uncomfortable, made her report with the Grosse Pointe Park Police Department to document it. She felt someone was trying to get information from her. Tim Lennon was directed to get information, which is very odd for a private investigator no longer on the case to reach out to people involved in the case to get info as to what resulted in the defendant going to jail. So that's just the backstory. Fast forward a few weeks. In the jail calls, the defendant is informed by her husband Dan that boyfriend, now ex-boyfriend, texted Dan saying he broke up with Carol. Defendant makes numerous detailed messages. This is verbally and in text messages of different allegations about to tell Dan to get Dan the most upset.
This is in the jail calls and
Yes.
jail text messages?
So, you know, allegations of cheating. The defendant says, make up, tell him I was suicidal. I don't care why. I'm just trying to make Alvin very angry with her. That's the clear intent. We don't have messages that Alvin ultimately received, but what we do have, which I can give to defense counsel in court, is defendant instructing Dan to send messages to him. And all these messages are things that are clearly gonna upset or hurt who was the person who came in on the day of sentencing, because your Honor knows was a protected person in the case. So I think that's where we're at. The direct contact part is a little bit gray, or indirect contact part's a little gray, but I think for the court's just edification of where the thought process of the defendant is, that's where it's at, along with, you know, calling every curse word in the book and repeatedly talking about it.
Okay, Mr. Smith, you don't have to address any of these right now if there was.
Just one thing that both parties are forming here. Nobody reached out to Alvin, so what I've been told. This would be that no one reached out to Alvin. Alvin reached out to Dan because they know each other in the past. And this may be uncomfortable for the person sitting behind me, but according to what I know, Alvin reached out and stated that he had broken up with Is this on YouTube?
Yes.
I'm not-
So
I'm not
let's
saying- yeah,
keep-
minimal. I'm surprised. We'll deal with this in the back.
So
I don't want to make any better.
So here's what I would need to see, okay? One, a specific conversation, I thought, with Ms. Hobson about what I expected her mindset to be. And she made some statements on the record, and I said, stay in that moment, all right? Now, there are some suggestions that she's still not there, all right? She's still not in that place. Now, again, these are just suggestions, and again, I want to make sure we are not in a violation hearing right now, okay? But this is what I would consider, just so that she knows going forward. I would consider this a violation of my probation if she told her husband to connect with somebody, or if they had a conversation with somebody to reveal certain things, certain confidences, things like that she knew would get back to the protected party. Like that's what's really interesting is I find that over time, having dealt with many stalking cases, there's almost a way in which some people try to justify or sort of get around a no contact order. One of the easiest ways is, all right, well, I'm not gonna have any direct contact with them, but somebody else will. Or sometimes we see this on social media. I'm gonna post something on somebody else's page, all right, who is friends with this person that I'm not supposed to have any contact with. I'm gonna say something that I know is gonna go back to them, that I know is gonna generate a response from them. That's a violation of a no contact order, because that is indirect contact, all right? A statement, a post, anything that is designed to get to that person. So even if her husband was contacted by this Alvin Williams person, if it happened after this conversation, again, these are lots of ifs because I don't know any of this stuff yet. But I want to make sure that we set the tone. What would I feel would be or consider to be a violation of no contact order? If she has directed him to reveal this information to Alvin Williams, and if the purpose is to get to the protected person, that's a violation. So again, we'll see if the prosecution, we'll see if probation can connect the dots, we'll see what you're able to provide. But I want to make sure that Ms. Hodgson knows, like, just the extent, if she uses an agent in any way, shape, or form, and that agent does something at her behest,
It's a violation.
that's a violation. Like, I thought, Ms. Hodgson, I thought we were on the same page when you left. Obviously, I had plenty of concerns that you wouldn't, based on some of your conduct, but I thought we were on the same page. Like, these people should be out of your mind altogether.
I told my husband to block him.
So hang on, so you want to be very careful right now, and I'm not saying this because I want a response, all right? But even when you're expressing frustrations, all right? Obviously, when you're sitting in jail, they make it clear that you're being recorded, okay? So you should already be practicing a life without them, all right? Nothing about their reality should be of your concern. If they are having great success, if they're having great misfortune, it doesn't matter. You have your own life, and everything you're doing is threatening your liberty, all right? And that includes staying in a negative mindset about it. Your thought shouldn't be, look what they have done. It should be, look what I have done to myself. And I mean, you're on two different, there's 2 or 3 probations now. You're on 2 different probations, okay? You have an outstanding warrant in Illinois, it's my understanding. Which, by the way, she's gonna have to take care of while she's on my probation, to complete my probation.
I've already started.
So, how much more does your own house have to burn around you before you realize that match? So, Ms. Hodgson, I really want to see, in the meantime, while we're trying to sort this out, okay, I want to see you get engaged with your therapy. I want to see that there's some productive efforts by you. Because as you can obviously see, Ms. Hodgson, I'm not asleep at the wheel. I'm going to be on this nonstop, all right? And if there is, the other challenge too is you have a specific court order prohibiting contact, all right? If there is a violation of that, all right, that could generate not stalking charges, but aggravated stalking charges. anything that counts as a contact in violation of a court order elevates it from a misdemeanor stalking to an aggravated stalking. All right, now we're talking about felony behavior. So I don't expect you, especially after we had the conversation last time and it doesn't seem to have had the response. I'm hoping over time I can work this message through to you. There is still time for you, Ms. Hodgson. If you follow my order to a T, they will be safe and happy, and you will be basically free from the reality of having to face a jail sentence and losing everything. Just follow my order to a T. All right, anything else, Ms. Linke?
Judge, aside from all that stuff regarding, she did present a new flip phone that she obtained after she was released from jail. She showed that to me at our appointment on Monday. She assured me it doesn't have access
Well,
to
did you look at it? Is there any?
I did not look at it closely. I plan on doing that today.
Okay, examine that, make sure that there's no internet access.
She did list all the devices in her possession, including serial numbers. I received those. She sent me the list of any social media accounts that she was not able to log into. There was an Instagram account that she had used to communicate with Miss that she initially couldn't remember how to get into, but she figured that out yesterday, and she and I had been in communication about that. So I knew she was going to try to deactivate that, which she did, and she sent me document proof of that.
And maybe you could help that detective, I don't know if you'd be available to help probation officer in, you know, I don't know, again, I don't wanna make it seem like Ms. Linke doesn't have the training when it comes to searching of a phone, but if you could help her with that, because it's part of the probation order. As part of the probation order, she was subject to random searches of any sort of electronic devices. So while she's here today, I just want to confirm that she doesn't have access. I want to make sure that that there's no sort of internet capacity that's available there. And Ms. Hodgson, as a reminder, your home, as part of your probation, is also subject to a random search. All right. And so, you know, there might be a situation where Ms. Linke reaches out to you, detective, about organizing that as well, because that is part of her probation. That's not something new. She knew of it at the time.
Can I say?
Go ahead.
Because this is an interesting point. So it says, the actual order says, no use of any form of social media on an electronic device. So, but social media, like let's say a person wants to order some food from Uber Eats or go on Google to buy groceries or whatever with that Instacart stuff. That's okay, right? I mean, she can use the internet to do stuff like that, but she has to report.
She has to report her use.
Use, not just so just report the use if she uses it. If she never uses it.
And she can't use, because there are some services that also include like a chat or something where you can send messages. Like these are like, it is going to be difficult for our probation department, and it's going to be difficult for Ms. Hodgson, because we're going to have to do a deep dive. And if she wants to use the internet, she's got to document it all. She's got to be able to list out. And the reality is that, I mean, I'm to the point where I'm close to just shutting it all down, completely. Like that's, I'm to the point where Ms. Hodgson's gonna go back to like the 1800s. I mean, we're talking telegraph, like, I'm exaggerating here, but that's where I'm at. Because I can't guarantee anything.
I think the difficult part with this too, which obviously I don't think presented to the court can effectively do to address the issue, is that we can have the defendant, like while she was incarcerated, just asking her husband, can you go to this website and get this candle? Can you go get this form? Can you go? I mean, does she have to track all these requests she makes for other people to go on the internet? If she's asking her husband, can you go on this website and do X, Y, Z?
But the reality is that if she is doing any business, either her or at her husband, or requesting her husband to do so, if she has a presence online, we need to know about it and what it's all about.
She's got to log it.
She has to log everything.
Yeah, so she buys a book on Amazon, she has to log it.
Correct.
She buys a soap on Amazon, has to log it.
Provide the receipt.
However she does it.
So, I mean, again, that's.
Or she can do what we're not ordering, but we're suggesting, which is, hey, 1800s was actually probably a lot better than what.
Well, frankly, for her right now, if she lived in a house without contact to the internet, I think she'd be in a whole heck of a lot less trouble than she is right now. So
And
that's my next step.
I understand, I'm gonna work on the mindset issue, because that's something I already, I mean, we're using the same words before I even came into this court, so at least we're on the right page, all of us, and that is the correct one. Somebody told me recently, if you're climbing up to the top of the mountain to find Zen, you need to know one thing. The only Zen you're gonna find at the top of the mountain is the Zen you bring with you.
Well, I appreciate that, Mr. Smith. I haven't yet seen any sort of mindset by your client that suggests that at all. Again,
She's gotta work on it, right? And that's what I was trying to say.
yeah. So, Ms. Linkey, obviously, let me know what else, and then Mr. Peskovich, if there is anything I can do with that. If that incident, if you're able to connect that at all, bring that to me. All right, and I will absolutely, we'll have a hearing, and the court, if you can demonstrate that connection, that's a violation. There is no ifs, ands, or buts about it, that's a violation. And so there is no game that you can play that won't ultimately end up with you behind bars. So those days have to be done. I mean, you just spent, what, 45 days in jail?
More than 7 weeks.
Right? And the reality is that if you end up, if that happens, if you demonstrate that, then not only is it a violation with me, that's aggravated stalking. That right there. A series of unwanted contacts, at least one of them in violation of a valid court order. All right. So anytime you play that game, you run the risk of having a felony. And now, right now, you have limits in place. Like Judge Barron can only give her a year. I can only give her 93 days. I think that's my limit. A felony is a 5-year. 5 years of your life gone for what? So, all right, when should we have our review / check and see if we're gonna have a violation?
I mean, at least, you took at least within 30 days, if not sooner.
I think that we could be ready for probation violation pretty fairly quickly.
Okay. Weeks. Now, if it comes to pass, Mr. Peskovich, that you're not able to connect the dots, we notify probation so that we can then cancel that hearing and to set up a regular review.
Absolutely, now let further comments.
Okay. And once again,
There was something in the probation report about defendant needing to remove all firearms from the home still.
Oh, yeah.
Just hoping that can be addressed.
Yeah, there is a firearm in the home, it's locked, it's my client's, the husband's
can't
firearm.
be in the home.
So I just told him that the court will instruct you more likely that you have to remove that immediately from the home.
It has
So
to be
he's gonna go and remove that.
immediately.
Immediately.
Okay. All right. Thank you.
Thank you.